Welcome, everybody. My name is Chai Feldblum. I served as a commissioner of the EOC for about 10 years, from 2010 to 2019. And about a month ago, with a few other people, I helped co-found Pride in Exile. This is an organization designed to stand in and provide support for federal LGBTQ plus employees who have lost access to their own LGBTQ affinity groups. So welcome to this first webinar hosted by this new organization, Pride in Exile. A word about privacy. We have been very careful about privacy. To everyone attending, the video, the audio, and the chat functions have been disabled. You cannot see who else is attending. This webinar is being recorded because we want everyone to be able to get this information, but no identifiable information for attendees is being captured. And I'll describe a bit when we get to the Q&A section, how we are protecting people's privacy there. But I am hoping that during this webinar, we can give you some good information and also some good support. So to kick us off, I want to turn to Jocelyn Samuels, someone I've known for a long time. Commissioner Samuels, if you could say a bit about yourself and some introductory remarks.
Of course. Thank you so much. Hi. I'm so delighted to be here with all of you. I'm Jocelyn Samuels. I use she, her pronouns. I was a commissioner of the EEOC from October of 2020 until January of 2025, and I have a 35-year career enforcing civil rights in both government and nonprofit organizations. And look, I think we all know that these are challenging times, particularly for the LGBTQI community. I think we can all feel like we are subject to a just relentless stream of attacks and attempts both to dehumanize people based on who they are and change government policy to reflect these damaging views. So I am grateful to all of you for all that you do, both inside and outside the government, and for your commitment to supporting your colleagues and your stakeholders. And I'm so delighted to be here with you today and so thankful to the founders and organizers of Pride in Exile for their work to put together today's webinar and more globally to build and support this community. I don't have any silver bullets to propose, but I will share with you a few thoughts and quotes which I have freely plagiarized from sources much more eloquent than I am, that I find give me some comfort in these challenging times. First, as Eleanor Roosevelt said, no one can make you feel inferior without your consent. In other words, let's not allow the current assaults to define who we are. I think I can speak for all of us on this call to say we see each other in the full and authentic ways in which we choose to live. Here's the second quote. Every action has an equal and opposite reaction. That's actually not a quote, it's a paraphrase of Newton's third law of motion. I have no idea what the law of motion is, but I like this concept because for all that we are going through now, the pendulum will swing. We've suffered periods of egregious stigma and discrimination before, and we've emerged strong and determined. These attacks will produce a backlash, which will open the door to further progress. And finally, and this is a quote we all know, the arc of the moral universe is long, but it bends toward justice. Progress is not linear. It can be 3 steps forward and 5 steps back, but history teaches us that we will prevail. So to ensure that we have the tools to push back and to continue to make progress, today's webinar is designed to give you information about your rights in the workplace as federal employees, as members of the LGBTQI plus community, and as defenders of the rule of law and the values of democracy. We're going to hear from distinguished experts and have time for questions. And beyond today, we want to hear from you about how this group can best support you in your work. This is a new group, as Chai said, and we want it to evolve in ways that will add the most value. So I encourage you to email us at Pride in Exile to share your suggestions, your questions, your thoughts. Those will help us to shape programming going forward.
My name is Anisha Queen. I use she, her pronouns. I am a partner at Brown, Goldstein, and Levy in Baltimore, Maryland. Our practice is varied, but we consider ourselves to be a civil rights law firm. We bring cases to fight discrimination in all of its forms, whether in housing, employment, or in the prison systems. Increasingly, my caseload is focused on representing employees both in the private and federal sectors. So I have been asked to explain the procedures for filing an appeal with the Merit Systems Protection Board, or the MSPB. What is the MSPB? It is an independent quasi-judicial agency in the executive branch of the federal government. The board is composed of 3 members, appointed by the president and confirmed by the Senate. Under the Civil Rights Service Reform Act, federal employees may file an appeal with the MSPB for, among other things, terminations, including discriminatory terminations, suspensions of more than 14 days, reductions in grade or pay, furloughs of 30 days or less, and reduction in force or RIF actions. When an agency takes an appeal action against an employee, the agency must provide the employee with notice of the right to appeal to the board, as well as the appropriate board, regional, or field office for filing the appeal. Importantly, as was just reiterated over and over again in the previous section of this webinar, deadlines are extremely important. So you must file an appeal with the MSPB within 30 calendar days of the effective date of the action. So if you are terminated, as a lot of probationary employees were on February 11th or somewhere around that time frame, you had to file an appeal with the MSPB within 30 days of that date. Typically, probationary employees can file with the MSPB in 2 very limited circumstances: if terminated based on 1, political affiliation, or 2, marital status. My knowledge of the MSPB appeal process has increased significantly over the last few weeks. Recently, BGL, with 4 to 5 other law firms, has filed class appeals to the MSPB, arguing that the terminations of probationary employees were constructive RIFs. So all that to say, probationary employees are permitted to also appeal to the MSPB concerning constructive RIF actions or RIF actions. Initiating an appeal is a very easy process. There's a standard form that you complete through the online MSPB portal, which requests your contact information, some information about your federal service, and the reason for your appeal. By completing that form, one has done everything that is required to initiate the MSPB process. If there is an SF-50 or similar notice of the personnel action, for instance, a termination, that should be filed as well. Any appeal must be filed with the MSPB's regional or field office serving the area where the employee's duty station is located when the action was taken. Once the appeal has been filed, the assigned administrative judge will issue an acknowledgement order, transmitting a copy of the appeal to the agency and directing the agency to submit a statement as to its reason for taking the personnel action or decision being challenged. The agency must also submit all documents contained in the agency record of the action. If the MSPB has questions regarding whether an appeal is within its jurisdiction, or in other words, whether or not it can hear the appeal, it will request a jurisdictional statement from the appellant explaining why the appeal is properly before the board. After the administrative judge has issued a decision on the appeal, an appellant can file a petition for review with the clerk of the MSPB in Washington, D.C. or with the United States Court of Appeals for the Federal Circuit. The court must receive your request for review within 60 days of your receipt of the board's final decision. Again, deadlines are extremely important. One thing I think is important to note, and is likely a nice transition into the next section, is that if a bargaining unit employee is covered by a grievance procedure that covers certain personnel actions that are appealable to the board, the employee has a choice between either filing a grievance with the agency or an appeal with the board, but that employee cannot do both.